All right, good afternoon, everyone. Welcome this afternoon to the webinar about what you need to know about antitrust laws. And we are thrilled to have with us today Brian Schneider. He is with Arndt Fox Schiff. I think I said that correctly. Let me know if I didn't. I want to make sure the marketing is correct. And we are thrilled to have him here today. He is a well-known, well-respected antitrust law attorney, and he is just gracious enough to join us today to record this webinar on how to stay out of antitrust hot water, which we all know we are facing in our day-to-day practice as real estate professionals. And so without further ado, Brian, I'm going to turn it over to you. I'm going to pin you so that everyone can watch you as we move through this webinar, and take it away, Brian.
Great. Good afternoon, everyone. Thank you, Miami, for having me. As she said, I am an antitrust lawyer. I'm based in Washington, D.C. with the Arndt Fox Schiff firm. And my practice, I mostly represent MLSs and realtor associations around the country, other trade associations as well, and try to keep them out of hot water. I'm currently defending several MLSs and representing a number of realtor associations in various antitrust matters around the country. And so the discussion today, I'm going to give you an overview of why antitrust is so hot right now for this industry. To kind of talk about what the concerns are, where folks are taking shots at you. And then we'll talk through some best practices, some things that I would remind everyone to think through to try to avoid problems or avoid even creating them. So I'll put up my slides, and hopefully you can still see me and my slides, because just my slides are not so exciting, and just me is not so exciting either. So I decided to entitle this presentation Antitrust Abounds because it is a little unreal how hot antitrust action is right now in the realtor space. There are nearly a dozen different actions going on trying to challenge how realtors do business, including on their own, including through the MLS. And I think it's really important to sort of get a grounding of what all of these matters are. So my goal as part of today is to go through those. So just to start, right? So anytime we have a meeting, I'm sure Miami does a great job when they have their meetings. You know, we set some ground rules for antitrust discussion. So I'm happy to answer questions today. And, you know, we've got a small enough group here that we could get into some good discussion, and I'm happy to get into it. This really could be an interactive discussion, but of course there are limits to that. And they're just like any discussion that Miami would facilitate. We're not going to talk about how we can avoid the antitrust rules and still set prices or limit competition, how we can refuse to deal with certain customers or certain brokers or certain vendors. We can't do that collectively under the antitrust laws. That's prohibited. We also can't agree on ways to avoid competition. Like, I'll take these customers and you take those, or let's make sure that I'm using these referral sources and you use those. I'll take the north side of the city and you take the south. Those kinds of arrangements among competitors are also automatically violations of the antitrust laws. There's some other nuanced ways that are violations of the antitrust laws that we're also not going to do today. Things like limiting marketing efforts. We'll agree, for example, if we all just stop using billboards, we can stop wasting that money and not compete on how to use billboards, right? And advertising that way. We're not going to agree how we pay our different contractors or different employees, because agreeing on payment of services, wages, and benefits is also a way to avoid competition, and gets a lot of employers right now into trouble. The Justice Department is very focused on employer action in trying to reduce wages and trying to reduce competition for jobs. And that gets also to the non-solicit or non-poach agreements. It's generally okay to require your employees not to poach or your employees not to solicit. There are ways to do that, and each state's a little different on rules, but generally okay. But what you can't do is agree with your competitor that we won't poach each other's independent contractors. We won't poach each other's employees. That's where you get into trouble, is if you agree with your competitor on these things. So that's really going to be our theme today, is that the antitrust laws are really all about protecting competition among competitors. The whole idea is that if companies are competing with one another, prices will get lower, services will get better. That's the concept of antitrust law. That's at the heart of antitrust law. And ultimately, antitrust law is designed to benefit consumers with those lower prices, better quality services, better quality goods. And you only get that through competition. We know, for example, that monopolies, if you have 100% of the market, you're going to be charging more and you're not incented to improve your services. So the rule under the antitrust laws is that if we are engaged in anti-competitive conduct, that's illegal, and there's private rights of action. You can get sued. The government can enforce it. They can, in theory, send you to jail. There's criminal penalties from the government. But not all conduct is anti-competitive. It's only anti-competitive if it restricts competition. And so you think about the examples that I just walked through of the ways that you could limit how we compete. Those are the ways that you can limit competition. And one of the biggest reasons why antitrust is so hot from a plaintiff's side, the folks who want to sue, the law firms who want to represent them, is that not only can you get your attorney's fees paid for, but you also get what's called treble damages or triple damages. And so if you lost $1 million in a deal because of an anti-competitive agreement, now all of a sudden you could recover $3 million in damages, plus get the other side to pay your attorney's fees and costs. So you're not out anything. You get 3 times as much as you were out. You had lost out on the deal. It's a pretty punitive statute, and it creates a lot of incentives for plaintiffs' lawyers and for plaintiffs to go ahead and try to sue. If they can come up with a theory that gets by the judge, that's what they're going to do because the money's there. On the flip side, it's very costly to be a defendant. Not only is there a huge risk of damages to a defendant, but the cost of defending an antitrust case is among the most expensive types of litigation that there is. There are cases that I've been involved in that can bill upwards of $1 million a year in litigation fees alone. And that's not even getting to trial yet. So we're talking really, really expensive litigation, high stakes, high dollars that you really just want to stay out of. So in this space, in the realtor space, the MLS space, the government enforcers, the Justice Department, the FTC, the Federal Trade Commission, as well as plaintiffs' lawyers, have really racked up a whole pile of theories and claims that have been going on for 3+ years now, a number of them only in the last couple of years. But I think they kind of boil down to these 3 propositions in general. Their arguments are that consumers would save money, they'd pay less as a home seller or a home buyer or a landlord if the MLS just got out of the business of facilitating offers of compensation. They also argue that the buyers or the renters should pay the broker if they want one. And if they want to have those services, they should be paying for them directly, that it shouldn't be part of the transaction coming out of the sales transaction. And then finally, they argue that the nature of the MLS in bringing realtors together is stymieing competition, that the rules that are set up to sort of facilitate this orderly market in an MLS is ultimately stymieing competition from lower cost models, lower cost brokers, lower service models, folks who want to just sell within their office, et cetera. There's a tax on all those. And so when you look at what I'm about to go through with you, when I go through the dozen or so litigations that are out there and enforcement matters that are out there, keep in mind that these are really the 3 things that all these cases are going after: that consumers would save money, that the MLS is ultimately facilitating payment where the buyer should be responsible for it anyway, and that there's all these other competitors who would be competing against realtors if only the MLS rules didn't stop them from doing so. Okay, so I've tried here to lay out in the simplest way the whole picture of all the antitrust actions that you're probably reading about in the news. If you're subscribing to Inman, you're probably seeing big, bold, flashing headlines all the time about major allegations and big decisions and things. Well, if we sort of go at it with a pretty neutral view, these are the cases that are out there. They have a couple different theories of liability, and they're in different statuses in the litigation. And I think it's important to keep them all sort of in context, right? So the first category of cases, there's four major cases, and there's probably a couple smaller ones that are out there following in their coattails, but there's four major cases that are arguing that the offer of compensation through the MLS, the requirement that you make an offer of compensation, even though it might be a penny or a dollar, that requirement that you make that offer of compensation is anti-competitive. And that as a result, these lawyers have brought on classes, big groups of home buyers and home sellers that they say have been harmed, have paid too much in broker fees. And their ultimate argument is that, well, in Canada and in Europe, the folks who pay their brokers are paying way less than they pay in the United States. And so there must be something wrong with the way that the US system works. And that something must be the offer of compensation, the offer to cooperate with the listing between the listing broker and the cooperating broker. And these cases, there's a couple of them. The leading case is Merle. That's in Chicago, and they are going after MLSs and brokers in 19 different markets around the country, and saying that their clients, the home sellers, paid too much for broker fees. There's this other case that takes the flip side of the coin, Leader, and that one says, well, we represent home buyers, and it's the buyers who pay the fee, and so it must be the buyers that are out the money, not the sellers. And so they have the flip side of the coin. It's going to be really interesting when the same judge now is overseeing those two cases, because the judges may actually ultimately decide the age-old question of, is it the buyer or the seller that actually pays? And I think most of you probably have a very strong opinion one way or the other on that. And certainly in each deal, the documents will make it clear which one is which. But this judge is going to have to figure out in this class who's harmed. It's unlikely that it's both home sellers and home buyers. I suppose it's possible in some cases if their theory is right. Then there's two more cases that are narrowed, same claim, that are just narrowed down to state level. There's one in Missouri and there's one in Massachusetts. And in each of these cases, in essence, they've sued NAR, they've sued the local MLS, and they've sued a number of brokerages. Some of them don't include the MLS, some of them do, some of them include certain brokers, some of them include other brokers, but as a general matter, that's the picture. And the biggest and lead case is Merle. They've subpoenaed dozens of MLSs and realtor associations around the country. They've done dozens of depositions now of employees and brokers and agents around the country. I was in a deposition for one of them the other day, and what the plaintiffs are trying to show is that this was all that all the realtors got together and said, we can only get away with keeping our commissions up if we stay if everyone is required to make an offer of compensation, and that if we remove that offer of compensation from the MLS, our commissions are going to go way down. And that's their theory. And fact discovery is ongoing, which means they're still doing depositions, they're still reviewing documents. Later this summer, they're going to hire experts, and they're going to start putting together expert reports in that case. That the experts are economists, and the economists are going to try to show, using all their analysis of real estate data, how much less the home sellers and home buyers might have paid if the rule were different. And of course, the defendants, NAR and the brokers, are going to have their own experts. And they're going to say why the home sellers and home buyers would not have saved anything, because the market would have worked exactly the same. Because the reality is you can put a penny or a dollar into the system. Many people do in many cases. And commissions fluctuate with the market just like any other good. Right now, commissions generally are declining in a hot market. That's how it goes. The one big upcoming date to watch for is probably going to come in May or June. In the Missouri case, the judge there seems very much aligned with the theories of the plaintiffs' lawyers. The other judges in the other cases, I think, are harder to read. But in the Missouri case, the judge seems to think that there's something to this theory that the plaintiffs have alleged. And the judge there is going to rule on what's called class certification, probably in May or June. And what that means when the judge rules on class certification is that the plaintiffs can proceed on behalf of all the home sellers in the state who might have been harmed. Without that, they were just proceeding on the one or two people who they got to sign up originally. And all of a sudden the economics change, right? The amount that could be paid for attorney's fees, the amount that could be obtained in damages are way lower. But if all of a sudden you represent everybody in Missouri who sold a house in the last 6 years, that's a lot more money. And so the judge has to rule that this case can proceed or not on that class basis. And that's probably going to come May or June. And it's very likely that if that judge says, yes, class certification makes sense, then the other courts may follow suit. And all of a sudden, starting this summer, the heat is going to pick up on these cases if that judge rules that way. So watch out for some headlines on that. I'm sure Inman will run with it. And I'm sure Miami will do a good job trying to make sure everyone understands really what does it mean for you. Those are the commission cases. There's also a bunch of other cases, unfortunately. So there are two cases. Keep going. Here. So there is two cases that are attacking the clear cooperation policy. So this is the policy that was adopted back in 2020 by NAR and by most MLSs that says that if you're going to market your property somewhere else, you also have to put it in the MLS. I'm paraphrasing, but that's generally the concept. And there's two what I'll call private listing networks, where they have a private club, a private set of members that privately market on their private website to whoever can see the private website, their contact list. There's the PLS.com and there's TAN, the Top Agent Network. And so they are both in separate lawsuits challenging that rule and saying that that rule harms them and their ability to gather listings from realtors. I'm representing several of the MLSs in those cases, and we've so far successfully gotten the case dismissed, but it's on appeal. And the Ninth Circuit out in California will rule later this year on whether that case can proceed and go back to court, or if in fact the case was properly dismissed and is over. Ultimately, though, what they're really attacking is just the clear cooperation policy, and it'll be interesting to see. Does that policy really make much of a difference in the MLS world, in the NAR world, to brokers? If those plaintiffs can proceed after the Ninth Circuit appeal. Then there's a case, a broker, a non-realtor broker, REX, real estate exchange, REX. They've said that because Zillow is splitting out on its site certain listings that are sourced from the MLS through the IDX feeds, because listings sourced from MLSs are being split out on the Zillow site from any other listings, like listings from REX, a non-MLS participating realtor, or in FSBOs are also being split out on Zillow, that's an antitrust violation. That Zillow's decision to split those out was part of a rule that many MLSs have, which says that if you have an IDX feed, you have to separate out the listings that come from the IDX feed, that come from all the brokers that are cooperating in the MLS, versus advertising other listings that don't come from there. Most MLSs in the country don't have that rule, but many do. And as a result, Zillow made a decision to create a sort that splits those two sets of listings out. And Rex is saying that that's anti-competitive. That case is also undergoing discovery now, and we'll likely have some more decisions probably by the end of this year about whether that case has any more legs. And then lastly, but definitely not least, is the Justice Department, the DOJ, and their investigation. into the activities of NAR and the MLSs. Many of you probably read that NAR actually sued the Justice Department in an unusual move to force the Justice Department to stick with the settlement agreement that it had signed. That case is pending decision by the court. And the court seems to be sitting on it. And so that might not see much action for a while. Maybe this summer or fall would be the next time we'll see that come up. In the meantime, the Justice Department doesn't seem to be pressing for more information. I'm not aware of any more subpoenas going out or more investigation being done, but it will. The Justice Department will come back and look at this, because by withdrawing from that settlement agreement that many of you are probably familiar with, that the Justice Department had entered with NAR back in 2019, by withdrawing from that settlement agreement, the Justice Department stated expressly to the court that they have more to do in terms of the investigation. They think there are more problems here than just with what was being settled. And it's no secret that they think that the requirement to make an offer of compensation through the MLS and the clear cooperation policy are both potentially anti-competitive. They are also challenging those two rules. Meanwhile, it is very likely that the FTC by the end of this year will start what's called a rulemaking process. They'll start issuing some regulations, and there'll be opportunities to influence those regulations through comments, public hearings. It's unclear what the FTC really wants to accomplish in its rulemaking. It's probably going to be around the offer of compensation and the requirement that you make one in the MLS. It's very likely that that's their target. It's much less likely that it's any of these other issues that are also on this chart. That remains to be seen, though. They have not made public what they're interested in, but the Biden administration's executive order, which instructed the FTC to issue a whole slew of rules under the antitrust laws in 18, I think, different industries. In real estate, they specifically said, the Biden administration specifically said to the FTC, we want you to address what's called tying two things together into one transaction. And that's almost certainly the offer of compensation is what they were referring to. So that is your landscape of all the different ways that your industry is being scrutinized and attacked. There are literally millions of documents, gigabytes of data being analyzed right now by lawyers and experts, both for NAR, the government, the largest brokerages houses in the country who are defendants, the MLSs. The volume of documents and information is massive, and it will be likely in the next year to 18 months where we start to get a more clear picture of what those documents and data actually say about the cases. Discovery takes a long time, and so I'm not anticipating really much clarity in any of these cases, probably until at least 2023, if not longer. So what does that mean for us? On a daily, weekly, monthly basis, right? A lot of this doesn't necessarily affect sort of what happens at your job. You're continuing on in your work. No one's stopping you from charging commissions. No one's stopping you from offering cooperative compensation to other brokers in the market. No one's talking about changing that rule today. And the reality is that that rule may not change for some time, even if it ever does change. So how do we deal with things today? What can we do to try to avoid getting into hot water? So I put these things into 4 buckets. I'd say anytime you're meeting with competitors, whether it's at a ethics committee, code of conduct committee meeting through Miami, or meeting with competitors for coffee to talk about what's going on in the market and how you can work together to get referrals or clients. You want to take really good care in making sure it's clear that you stay clear of the antitrust laws. And clearly, for a formal meeting, you stick to the agenda and you keep minutes. You don't go off script. If you're meeting for coffee, that's not quite as easy. And you don't usually take minutes or keep an agenda for that kind of discussion, but you still want to stay on the straight and narrow, because ultimately, anything that you end up sharing with each other that may be anti-competitive can come back to bite you, particularly if you send it in a text or an email. And I get to that in a second. When it comes to policy, MLS policy or public policy, rules and laws, free speech is protected in this country and in most states in the country as well. And so what that means is that coming together as a group of realtors to influence public policy is protected. You're allowed to advocate for particular laws and regulations. However, coming together to create an anti-competitive policy by a realtor association, so trying to come up with a rule that kicks out a particular broker or shuns a particular vendor, or doesn't allow commissions to be paid, or to be offered if it's less than 2%, right? All of those would be anti-competitive. And just because you're advocating for that policy does not mean it's protected. You would essentially be pushing for an anti-competitive policy, and that is conspiratorial. Under the antitrust laws, that would be a problem. What if you spot a problem? What if you hear a conversation or you are out at coffee and your competitor makes a suggestion? Hey, if we just did this, couldn't we all be better off? Your answer is, sorry, no, I can't talk about that, right? You're raising your hand as I put it here on the slide. You're saying, no, sorry, I can't talk about that. And when you go back to your office afterwards, write an email or pick up the phone to your office's legal counsel and make sure they know about what happened as fast as possible so that they can help you address it, so that it's timely reported, and so that if it ever comes back, it was very clear that you helped report this internally and that you did not engage in the problematic discussion. Same goes, by the way, if you're at a meeting of brokers, you're at a meeting of realtors who are facilitated by someone other than Miami that isn't as compliant with the antitrust laws. And there's a discussion that's had there, and someone stands up and says, we all just have to start charging our clients 6% or this is never going to work. You leave the meeting. You raise your hand and you say, I'm sorry, I'm not engaging in this conversation, and you leave. I had a client once tell me that they actually left and spilled their water on the way out so that everyone else would know and remember when that person left, because they saw the water get spilled, and they'll actually be able to remember that moment. Yeah, right, Jill left and the water spilled. People do that. Last comment is emails, texts, and posts. So what you put on social media or text to anyone, even if it's on Snapchat, is discoverable. And you should just assume that it will be seen and misunderstood, because I know that everyone on this call is super careful about what you say, what you write, is probably very specific in your writing. Just assume that it will be misunderstood. Just assume that something about the tone or the context of your email or your text or your social media post will be read by someone to mean something anti-competitive or something otherwise illegal. And just take really good care in what you say or post. If it has anything to do with these topics that we talked about in this presentation, don't post it, don't text it, don't email it. Pick up the phone and call your lawyer, your MLS's lawyer, your legal, your compliance team, and work through it on the phone. Avoid the problematic posts, because that's how folks get into trouble. And what's a problematic post? Hey, I'm so careful. I would never have a problematic post. Well, here are some actual examples of real things people have done that got them into trouble, and they're a great sort of list of do not do this, right? So, don't put into an email, or frankly say at a meeting, if we all just did this, it would all work out okay. It would protect us, right? Or we all should go this way. If you're starting your sentence that way, it probably means you're trying to create an agreement among competitors that's probably anti-competitive. Don't say things that are, according to you, industry standard or industry practice or industry policy that actually aren't and actually might be anti-competitive. So, saying things like it's industry standard to charge a client 6%, or it's industry standard to pay 3% no matter what we charge our client. don't say things like that when, that's not necessarily true, and it does imply some sort of anti-competitive agreement. Avoid applying impropriety. This happens so often when someone says, this may be illegal, but I'm going to say it anyway. Or I'm not sure if this violates the antitrust laws, but here's my question. I always like this one, delete this email after you read it. Those emails and texts get discovered by lawyers all the time in the course of discovery and response to subpoenas and litigation. And it is so fun to sit in a deposition and ask someone, so why did you tell them to delete this email after they read it? What prompted you to say that? Folks never have a good answer for that. That is helpful. And then lastly, exaggeration. Talking in an online forum, maybe or in a meeting that says, oh, this is absolutely going to get rid of X competitor. There's no way they're going to be able to compete if we do this. It's almost certainly exaggeration and sounds a little silly, but when read out of context, it really sounds bad. And again, when you see those emails as a litigator going into court, those are the ones that we dream of, that we're looking for and saying, aha, we got the good email here because it says exactly what we wanted. They knew this was going to kill that competitor. All right, I've talked quite a while. What is on folks' mind? Questions, concerns? What are the questions you're hearing that would be helpful to talk through?
Folks, please feel free to come off camera or come off mute and have a conversation with Brian. This is your chance to pick his brain. And I'll kick it off, Brian, right? Because I often get these questions over email, no less. And luckily, I don't recognize any of the names in our session today, but I often get questions over email. What can we do about the competitor that shall not be named in our market now? And what is our MLS and what is our association doing about this? Is that a go or a no-go question?
Right. So the what can we do about X conversation. So the helpful answer, right, is there a violation of our code of conduct or rules that you can point me to that they are violating? If not, no, we can't do anything to exclude a competitor, harm a competitor. And moreover, remember at the top of the discussion, I was talking about how the antitrust laws are all about agreements that harm competition. Anytime an association of professionals develops a policy, that is a reflection of a likely agreement among the professionals, among the members. And so if we issue a policy, or if we issue a decision, or if we take some action that harms a particular competitor, it can be argued to be a de facto antitrust violation.
So folks, if you ask that question, tell your friends and colleagues that they asked that question, that is the answer that they are going to get from the association. And we've got a great question in the chat, Brian. If a brokerage wants to charge X% and tells all of the agents of that brokerage, that's what they will charge, is that okay?
Right. So this is within your brokerage. Can you tell your agents that are being supervised by the supervising broker what the fee must be to individual home owners? Right. I think that's what that's asking. Not the split, not the offer of compensation to other realtors. Right? What can you tell? What can you charge your clients? And I see the correct comment there. Right. So as the supervising broker, right, you're responsible for setting the fees and commission charges, right, to clients. However, you have to be careful when it comes to independent contractors because they can form an anti-competitive agreement among your independent contractors. If they're not employees, right, there could be a conspiracy, right? So you can absolutely instruct you can educate your independent contractor agents around those fees, right? And you can set the minimums that they ultimately are responsible to you for. And so that's typically how the arrangement is set, is that, if you agent are engaging in any deal, I won't sign it if it's below X%, but they can go off and negotiate beyond that.
Right. And that's also what I was going to make sure that we covered, Brian, which is, make sure that everyone knows that commissions are always negotiable. And I'm going to post some resources from NAR in the chat, which I'll also post on our legal updates page after this. NAR has a really good article on and guide on Article 16 of the Code of Ethics. So I'm going to post that in the chat for everyone's reference. Yep. And we have a follow-up question, Brian, which is, if the broker offers 100% commission, should we disclose that to clients?
And I have to admit, I don't know what that means, 100% commission. Does that mean that they're offering everything they get paid as cooperative compensation? So it's 100% goes over to the other side?
I'm not sure.
Or is it just not a split with the agent? So the agent gets to keep everything. Is that maybe?
That's the way I'm interpreting it. And the person who asked that in the chat, if you want to follow up with some clarifications, we can ride under that assumption for now that it's one-sided, right? Because the question that we often get at the association is, right, agents receive 100%. Okay, Brian. Yeah.
Yeah. So look, the best case scenario is that the client understands what they're paying and what services they're getting for what they pay, right? That should be the heart of every listing agreement. So it is, however, unusual for the home seller to know what their agent's split is with their supervising broker. And so the notion that the agent doesn't keep 100% and share some of it with the broker, or does, or what range is in there, to my knowledge, is not something that's typically in that agreement or is disclosed. And in most commercial contexts, that is not required, right? It is not an element of required disclosure.
And something along those lines, the question that we also get, Brian, all the time is, I've got a buyer, and my buyer's looking for 3-bedroom house, 2 bathrooms in the city of Miami, whatever the specifications are, right? And I go through the MLS and I pull all the listings that match what they're looking for. But lo and behold, there are a bunch of listings that only offer $1 compensation for, half of the properties on there. What happens if I decide not to send those along to my customer? What happens?
What happens, right? So this is probably actually a great question for you, because this is less an antitrust question and more of an ethics and compliance question.
Yeah.
But I'll start with the antitrust question, which is that we certainly cannot agree not to show clients listings that are pay under a particular amount. Like that kind of agreement is part of the litigation going on right now. And if agents were agreeing not to show those properties, that could be really problematic under the antitrust laws.
And Brian, to push back, well, I'm not making an agreement with anybody. I'm just saying, you know what? I'm not going to do that. I'm doing my work. I, want to make sure that, my customer would still be satisfied with the other half of those listings that are not offering $1 compensation. And I didn't agree with anybody. Nobody told me to do that. Is it still possibly an antitrust violation?
Sounds like a serious ethics violation, and probably a licensure problem. Yeah. But a unilateral decision that you make on your own is not an antitrust problem.
Got it. Okay. Yep. And any other questions in the chat? And you're right, Brian. Don't do that. You don't want to end up in our professional standards proceedings. And any other questions from our participants today? This has been really wonderful, Brian. I can't thank you enough. It's clear, it's really helpful, really practical advice. And we can't thank you enough for this.
Oh, you're welcome. It's my pleasure.
Any other questions from folks in the audience before we wrap up today? All right. Well, as always, thank you. And we will post this on MiamiRealtorsLive.com, and it will be on MiamiRealtors.com/legal updates in short order. And have a great afternoon, everyone.
Thanks, everybody.
Bye, y'all.